At the stroke of the midnight
Question
hour,
is whether you want to be you or everybody
I
else.
still have a dream. Patria o muerte.
Recently, the Supreme Court of India has delivered a landmark judgment in relation to the existing reservation policies within the territory of India. In simple terms, the Supreme Court of India has stated that the subclassification within the scheduled caste for the purpose of reservation or special treatment may be performed by the concerned state government, even though the notification of scheduled caste list is the authority of the President of India under Article 341 of the Indian Constitution. So in this video, we will be looking into the constitutional provisions of this particular judgment, as well as we will see the historical analysis of this issue in detail, and possibly we would be able to explain the future perspective or the future or the impact of this particular judgment on the socio-political scenario of the Indian society. So welcome to the explainer video of ClearIAS. Recently, the Supreme Court of India has delivered this landmark judgment and stated that even though Article 341 of the Indian Constitution provides exclusive right for the President of India to notify the scheduled caste list, that even does not bar the state government to subclassify the scheduled caste for the purpose of specific consideration for those backward communities within the scheduled caste. Now, when you look at the Constitution of India, Article number 15 states that the state shall not discriminate on the citizens of India only on the grounds of religion, race, caste, sex, or place of birth. And what does Article number 16 says? Article number 16 provides for the equality of employment opportunity in the public offices, which means Article number 15 as well as 16 says that the state shall not discriminate citizens of India on the grounds of religion, as well as on the grounds of race, as well as on the grounds of even caste. This is the focus point. Now you know, even though Article number 15 and 16 says that there shall not be discrimination on the ground of caste, a positive kind of discrimination is a necessity for enhancing the principle of social justice. And that is the reason, through the subsequent amendment of the Constitution, various times the government has put forward the idea of exceptions to Article number 15 and 16 to provide for specific treatment for those communities which are socially, educationally backward and even financially backward, that is the EWS category. Now, initially the reservation was extended to the scheduled caste. That means a 15% reservation was extended to the scheduled caste and a 7.5% reservation was extended to the scheduled tribe for just 10 years. But through the subsequent amendment of the Constitution, this particular reservation provision was extended, even considering the vote bank politics by various political parties in power. Now, altogether, that is a different matter. Now, as I have already told you, initially the focus was on the SC/ST community only, which means the OBC category was not touched. Now, it was in 1979, the Morarji Desai government appointed the second Backward Classes Commission, which is popularly known as the Mandal Commission. BP Mandal was a member of parliament, and Mandal Commission was provided the term of reference to study or to investigate about the situations of the social and educational backwardness of certain classes or certain communities. In 1980, the Mandal Commission has submitted the report, and as per the recommendations of the report, 27% reservation or 27% of the seats needs to be reserved for the other backward classes, and that was the most important flashpoint out of the recommendations of the Mandal Commission. Now, even though the report was submitted in 1980, it was not executed till 1990. That means it was executed in 1990 by the VP Singh government. In 1991, the PV Narasimha Rao government has introduced 2 more provisions, which means basically a creamy layer concept was introduced, which basically means that in the public employment, within the other backward classes, if certain community comes beyond a financial criteria or an economic criteria, they will not be provided with the privileges of the reservation, or they will be excluded from the ambit of the reservation privileges. That is what is the concept of creamy layer. So that was introduced by Mr. P.V. Narasimha Rao. At the same time, Mr. P.V. Narasimha Rao government has also introduced for 10% reservation for the economically weaker sections in matters of the public employment. In 1992, in the famous Indra Soni case judgment, the Supreme Court has struck down the second provision, which means the Supreme Court has said that providing 10% additional reservation for the economically weaker sections would violate the limit of 50% reservation per year, which means the Supreme Court said that the reservation, if goes beyond 50% of the total seats on one particular year, would be in violation of the Constitution. So the 10% reservation of the economically weaker section was struck down by the Supreme Court of India, but at the same time, the Supreme Court has held that the creamy layer application would be justified. So that was in fact what you need to understand in relation to the recommendation of the Mandal Commission and the reforms in the reservation system as per the recommendation of the Mandal Commission. Now, being said so, still there were 2 problems. And what was the problem? Number 1 was there will be absolutely certain forward communities or certain forward families within the SC, ST, OBC classes, and providing them with the privileges of the reservation again and again will not empower those who actually need the benefit of the reservation. So with the application of the creamy layer, the problem was somewhat rectified within the OBC community, but still SC, STs were not touched. Now, this particular judgment of the Supreme Court is in relation to the scheduled caste specifically. Apart from the question of creamy layer, another question which is present is that whether the subclassification of scheduled caste is a necessity. Because as you know, within the scheduled caste, there can be certain families which may be that forward, and there can be even backward communities within the scheduled caste. So the question here is that the subclassification, will it be a necessity or not? And you would have came across that whether, different political parties, even as part of the ruling front, has been in demand of a socio-economic caste census, just like the Janata Dal United, the Telugu Desam Party, pressurizing the BJP government or the NDA government to come forward with a socio-economic caste census can be understood from this perspective. Now, was this the first time the Supreme Court considering this particular subclassification of the scheduled caste for the purpose of reservation? In fact, the answer is no. When you see the history of this particular issue, in 1975, the state government of Punjab has came forward with an order that within the existing 25% of the reservation, the state government of Punjab has categorized into 2 groups. That means category 1 based reservation would be a special treatment for the backward communities within the Sikh community, especially the Balmiki and the Mazhabi community. Category 2 was including all those other scheduled caste community. So this particular decision of the Punjab government in relation to the subclassification of the scheduled caste has occurred in the year of 1975. Following this, there was efforts by the Tamil Nadu government and even the Andhra Pradesh government. But this time, in 2004, this decision of Andhra Pradesh government to subclassify the scheduled caste for the purpose of upward social mobility was struck down by the Supreme Court in the famous E.V. Chinnaya case. And what was the justification given by the Supreme Court for striking down this particular order of the Andhra Pradesh government was that Article number 341 gives or empowers the President of India to notify the scheduled caste list, which is an exclusive power of the President of India. And the state government should not interfere in this power of framing the presidential list, which means the state government should not interfere in the power of the President of India. If the state government tries to interfere in the presidential list, that would be found unconstitutional in nature. And later, even in the state of Punjab as well as in Tamil Nadu, this particular order was struck down by the respective High Court. Now, when these batch of petitions finally reached the doorstep of the Supreme Court of India, the Supreme Court of India has this time made it clear that unequals needs to be treated unequally. Equals may be treated equally, but unequals needs to be treated unequally to reap the real benefit of social justice. Now, what are the key takeaways from this particular judgment of the Supreme Court of India, which allows the concerned state government for the subclassification of the scheduled caste? Number one, the Supreme Court has made it very clear that the state can modify the presidential list, which is very, very important in the sense that the state's rationale should be very clear. It should not be merely for the vote bank politics, but still the state government can interfere in the presidential list. So that is takeaway number one. And number two is that this kind of subcategorization should be only on the basis of data and information. Now, what can you infer from this particular judgment of the Supreme Court of India or this particular observation of the Supreme Court of India is that the Supreme Court pushes for even a socio-economic caste census. It is something which we will have to wait and watch. And these kind of issues, especially the reservation related matters, does not have an end per se. We will have to see what are the possible changes in the coming periods ahead. So till then, it's a goodbye.